And while they make their way up here, I'm going to ask a couple questions. Just keep us all awake. I know the last panel before lunch is always a tough one, so let's try and stay awake here. So how many in this room consider yourself a tobacco control advocate? How many in this room consider yourself a housing advocate? How many in this room consider yourself a tenant? And how many in this room consider yourself a landlord or property manager? And how many raised your hand for all of those things? Maybe not all of them. 2 out of 3? Well, great. It's good to see that we've got such a wide range of folks in here. We're having such a great conversation, and now we're going to talk a little bit about some of the challenges and emerging issues that are happening around multi-unit housing. And so each of the panel folks here are going to have a quick kind of few minutes to talk about their issues. Keep filling out those cards, raise them in the air, and someone will come around and grab them, and we can answer some questions. So I am going to start with Jessica Breslin with she is a Change Lab Solutions policy expert in secondhand smoke and tobacco retail.
Hi, my name is Jessica. I'm a staff attorney at Change Lab Solutions. We provide statewide technical assistance to cities and counties that are looking to pass laws related to secondhand smoke and also the tobacco retail environment. And we're currently developing or updating our models for smoke-free multi-unit housing and also comprehensive smoke-free places. We offer a lot of different resources, not only for government entities, but also for landlords and for tenants. So I'd highly suggest you take a look at our website. And we're also available for questions. If you want to reach out to us, we provide technical assistance. So if you're a city or a county that's looking to pass smoke-free housing and is running into issues like the rent control issue or whether or not cannabis should be included, please send us an email or reach out to us, give us a call. We're available for consultation in certain circumstances. We can also draft ordinances or provide edits. But it's definitely an important issue, and there's lots of different challenges that come up, and they may be very unique to the city or county that you're working in. That's something that we can take a look at. So if there are weird rules, I mean, if you've ever looked at a city code, there's often very weird organizations and rules in there that might complicate things. That's the kind of thing that we can help with.
Great. So we will go down the list here, and I will hand it over to Anna Ortega, the Director of the Rent Stabilization Division for LA Housing and Community Investment Department.
Good morning. Good morning. So it was my pleasure to work with the UCLA policy staff on this project, and the REACH project, on the development of the smoke-free housing policy for rent-stabilized units. A copy of this, I believe, is in your packet. And there's some out on our display table in front. So basically, the rent stabilization ordinance exists to protect tenants, existing tenants. And it's a very important stabilizing law for our communities. Landlords are able to adopt smoke-free housing policies, but they need to think about doing this up front. So they can put anti-smoking policies in their leases, and at that time, landlords and the prospective tenants are free to agree to the terms of what they want in their lease. So it's very important, not just for smoking actually, but for any kinds of policies and house rules that landlords want. It's very important to have a lease, a written lease, and that everybody understands what the expectations are under that lease. So landlords have a lot more leeway with prospective tenants and new tenants. They can adopt smoke-free housing policies, they can inform tenants about the benefits of a smoke-free policy, and they can require a prospective tenant to sign a lease, a smoke-free lease. But after that, it needs to be voluntary and upon tenant turnover. So if a landlord has existing smoking tenants and wants to make it a smoke-free property, they're going to have to take the long view and do it vacancy by vacancy. So for existing tenants, landlords cannot unilaterally change any policy. but they can inform tenants of the benefits of not smoking. They can't require a tenant to sign a smoke-free policy, but they can request it. So, and there's a lot of benefits, of course, to having a healthy, non-smoking environment. At our display table, we have a guide for LA tenants, LA renters. This might be helpful to any of you that want further information about what the rent stabilization ordinance provides for tenants and for landlords.
Great. And now I will turn it over to Liz Williams, project manager for American for Non-Smokers' Rights Foundation.
Great, thank you. I was asked to provide the A&R Foundation's perspective on how the legalization of marijuana and the growing understanding around third-hand smoke contamination in apartments can help or can impact the smoke-free housing work that we're all doing. And I think it's really wonderful that Los Angeles is looking to expand smoke-free air protections to include multi-unit housing. And these are some good perspectives to hopefully consider. I want to start with marijuana since that is such a hot topic, especially now that the state has legalized recreational use. And at A&R, we get so many calls from residents in apartments and condos about drifting secondhand smoke, and as I know so many of you in the room do, and the last few years, those calls have really been ticking up in terms of it being marijuana smoke exposure, often either on its own or often in combination with tobacco smoke drifting or even vaping aerosol drifting. So this is definitely a pressing issue for this product to be addressed. Right now, the focus in many communities around marijuana is on getting all of the regulatory processes set up in terms of getting businesses to open, so the zoning and the licensing and all that. And it's hard because the concerns around the health risks, especially around the secondhand marijuana smoke exposure, can really kind of get lost in these conversations. We're trying to help amplify the conversation around ensuring that just like any other form of smoking or vaping, that marijuana should not be used in a way that that harms other people, we don't want marijuana use, whether it's for recreational or medical reasons, to result in creating a health risk for other people, especially in the shared air space of an enclosed building like multi-unit housing. Our goal is to ensure that smoke-free spaces are smoke-free regardless of the type of smoke, whether it's from marijuana or tobacco or even the e-cigarette aerosol. So we do recommend that individual building policies as well as local multi-unit housing laws do include the smoking and vaping of marijuana in their protections, not only to reduce the secondhand exposures, but also to be consistent and to help with compliance, because it's really hard to know what product someone is using, and we know that there's often mixed use of products, and so it's much easier for both residents and landlords to have some consistency across the board regarding all of these smoke products not being permitted in the smoke-free spaces. We do certainly recognize that this is a very complex issue on all facets of the marijuana in terms of regulation and use. And from our public health perspective, we're trying to have clear messaging on wanting to ensure that everyone can breathe smoke-free air, and that's kind of our starting point. But also we want to emphasize that people can be in support of using marijuana, whether it's recreational or for medical reasons, but also at the same time supporting not using it in ways that harm other people, keeping those smoke-free spaces smoke-free. There are some challenges regarding marijuana legalization and regulation that are across the board, whether you're talking about workplaces and public places as well as multi-unit housing, and those are the fact that there is a lot of or lack of awareness right now around some of those concerns about exposure and health risks. We do have some fact sheets on our website, which is no-smoke.org, about what the known science does say about some of those health risks to secondhand marijuana smoke exposure, especially around the respiratory component, because any type of inhaled particulate matter creates respiratory risks. There's also the fact that these marijuana regulations are happening at both the state and local level, different jurisdictions. It can be really confusing. People don't really know necessarily what applies in their area, or even if even when you think a regulation is final, there still might be months and months of input in figuring things out. So there's still a lot that is up in the air right now. And then there are some of the concerns around marijuana regulation and use that are specific to multi-unit housing. One is that we hear, and I've talked to others who have heard, that landlords aren't entirely sure, in cities too, whether they can even include marijuana smoking in their multi-unit housing policies because they know it's now legal, so they just don't even know if there's any regulatory capability. So that's a educational gap that we can work to fill, to say that smoking marijuana can be included in smoke-free policies. There's also the challenge that Councilmember Koretz alluded to earlier, is that California law does not allow marijuana smoking in public places. So there could be concern about where can residents smoke it if they cannot smoke it in their apartment or condo. And to my understanding, California law doesn't give a specific definition of what public place is, but it is largely understood to be the outdoor spaces within public view. So maybe something that a community could consider would be, whether it's feasible to allow smoking in an outdoor space that's out of public view, or a community might want to even push the envelope on, what is considered a public place, so that people aren't targeted for their marijuana smoking if they're in a responsible type of outdoor location that isn't exposing others. Also, it's always helpful to highlight that there are the edibles and other, non-smoked varieties available. And then the other big marijuana concern with multi-unit housing that, or challenge, is around that, there might be pushback from some stakeholders who are really worried that including marijuana in smoke-free housing laws can impact the, equitable application and enforcement of smoke-free laws, especially around the housing insecurity issue if their landlords were looking to evict people. So we really want to broaden the conversation, I think, to try to get some collaboration with different housing stakeholders, with tenants' rights groups and others, to try to think about how can we minimize any negative repercussions of including marijuana smoking in these policies, so that we can be protecting all residents, both those who use or smoke marijuana, but also those who are being impacted by the drifting smoke. And then one example I want to give, the city of just having that type of conversation and thinking through a creative way, was the city of Pleasanton up in the Bay Area. Last summer, they passed a smoke-free multi-unit housing law, and they were trying to think about what to do about medical marijuana. And they decided to say that there's no smoking or vaping of anything inside the building, but they could allow, buildings could allow an outdoor area for marijuana smoking if a resident got a note from their doctor that their medical use really could only be, or medical need could only be met by smoking it. And that law has not gone into effect yet. It goes into effect in the fall, so we don't know what that'll look like in practice, and that may not be a type of solution that would be feasible for other communities, but I thought it was a good example of how they had the conversation and really wanted to try to be innovative and figure things out. So I think that's a big takeaway, is more conversations and creative problem solving. Then just briefly regarding third-hand smoke, we know, so how many people, raise your hand if you know what third-hand smoke is? If you're familiar with the term. Okay, so most people know that it's that sticky, smelly tobacco residue that's left behind on the spaces after smoking has happened. And it's the costs that are associated with the third-hand smoke residue is a big motivating factor for landlords to implement smoke-free policies to address those turnover costs and time that it takes to make a unit habitable. But there's that growing body of scientific evidence from researchers, especially here in California, that talk about how the third-hand smoke stays around for months and months, even after cleaning, and it can expose people, new residents in an apartment or home, to the third-hand smoke. Okay, they can have the biomarkers of tobacco in their bodies, and also that it is exceptionally difficult to clean this third-hand smoke residue. So right now, the best way to prevent third-hand smoke exposure is to say all buildings need to be smoke-free at all times. So you can't have third-hand smoke without the second-hand smoke first. So having policies that say no smoking by all residents at all times in the building is really important to prevent that third-hand smoke buildup. So partial policies that say only some units, or grandfathering of tenants, those really aren't effective at addressing the third-hand smoke, as well as, of course, the second-hand smoke. But in terms of, after speaking with the researchers, in terms of what to do about the existing third-hand smoke, you know, what if you have a smoke-free law or policy and people do a great job of no longer smoking in their apartment? Well, what do you do about the residual third-hand smoke? The researchers have said they just don't have the science yet to say what exactly effective cleaning is, so we don't really have, you know, a basis for what any policies could look like around that. So, you know, right now there's just the disincentive of, you know, not getting your deposit back, for example, for cleaning reasons, for cleaning costs. But I think that with third-hand smoke, there might possibly be more ideas of what we can do in the future if we get more science that can give us an evidence basis for some guidelines. But right now, just making sure that the smoking spaces are, you know, working on compliance with smoke-free laws and policies is the best way to deal with third-hand smoke.
Thank you, Liz. And we'll take some questions, but I actually have a couple questions for the panel as well. So we've talked about some of these challenges of having a government policy, the idea of how do you deal with a rent control policy, how do you deal with the marijuana issue, and how do you deal with third-hand smoke. Do you guys have any recommendations?
Yeah, I think there have been a couple there's different options to think about. Someone earlier mentioned Berkeley. Berkeley is a rent-controlled city, and they have just separated the smoke-free multi-unit housing from the eviction and lease process, which sort of gets around that you can't add new lease terms to an existing lease without consent. And I think there's different options that you can look at, and that would be one of them. We always encourage, you know, a graduated enforcement system, which you want to look at. But I would definitely recommend reaching out to us if you have more specific questions about the jurisdiction that you're in.
Any other?
Around enforcement, in terms of the actual policy language, yeah, I think trying to help. So I think one thing that we might be able to learn from some of the housing authority policies that have been adopted by in many communities, including I know here in Los Angeles, is they often do a good job of spelling out what is expected of both parties, both residents and landlords, in terms of their responsibilities, and not just from, you know, a penalty type perspective, but also from an education perspective. So providing some guidance in policy language, or at least in the implementation guidelines, I think can be really useful, so that we are giving people, both the housing providers and the residents, the education they need to know how to comply, and so try to ward off you know, problems down the road, you know, because we don't want people to be caught unaware. We want to give that support to the people who smoke especially, but you know, maybe putting some of that guidance in actual policy language could be useful.
So I would just say that communication is really important between landlords and tenants, and between prospective tenants and their landlords. And it's very important in all landlord-tenant policy issues to get everything in writing in the lease.
Thank you. Now I'll turn it over to Ricardo.
So we have a lot of questions. The first one is, has there been any discussion about the LA City Housing Department staff about the smoke-free housing law passed by the city of Berkeley in 2013? Berkeley has a rent control law just like LA.
I don't know that anyone up here knows the answer to the conversations LA County is having. Is there anyone that wants to take a stab at that? Well, why don't I recommend that person find me, John, or Marlene after we break for lunch, and we can figure out how to get an answer for you, since none of us have that answer right now.
All right. So now that we know that third-hand smoke causes damage to health, and now that the landlords are on notice that if a smoker moves out and a non-smoker moves in, the carpet, wallpaper, paint might be poisoning to the new tenant. It is in law, landlord legal liability if the tenant gets sick after a landlord failed to change carpet, wallpaper, and paint. I think this is more of a comment. The next question. Oh, the question? Oh, so the question is, are they legally responsible for it?
As far as I know, they are not. I'll let
So there's usually a cleaning fee between tenancies. So presumably the landlords are preparing the unit, and that's a common business practice that they clean up and paint and get the unit ready for a new occupant. But there is no legal liability established for prior smoking in there. But the practice of landlords is to spruce up units usually in between tenancies.
And I think separate from a legal liability, there are reasonable accommodations. So if there's third-hand smoke in your apartment and it's affecting you on a regular basis, you can ask for a reasonable accommodation. On our website, we have tenants resources, which you can separate by city and county, which should have organizations who can help you with requesting a reasonable accommodation. So it wouldn't be legal liability, like you can sue for damages, but sort of it can be things like putting in a different type of ventilation system, if there's a different unit available, moving to that unit, things like that.
All right. Can you discuss the legal difference between marijuana, recreational versus medical, and how does it apply to regulation?
To the regulation of use in general, or the regulation of use in
It's
multi-unit housing?
marijuana recreational versus medical.
I can try and give a step. So one of the main differences is in order to smoke medical marijuana, you can start smoking at 18 with a doctor's recommendation, whereas you need no recommendation for recreational marijuana as long as you're 21 and over. As far as secondhand smoke, it is currently in state law that it is prohibited to smoke marijuana anywhere that it's already prohibited to smoke tobacco. So those are some of the main differences. Generally, when we're talking to people who are drafting these policies, we recommend not distinguishing between medical marijuana and recreational marijuana, so not having a policy where you allow one but not the other, because it can get very tricky and complicated for enforcement issues. Where you might be invading someone's personal or private medical information, which they don't want to share with you, and also just how to distinguish that if you see someone smoking. I mean, that's not really something you can tell if it's if they're smoking medical marijuana or recreational marijuana. There's also differences in the tax rates.
And just one thing to add, I mean, in terms of the actual products, there might be differences in like the edibles and such, but it's usually the same exact marijuana. So in terms of the secondhand smoke, it's not that there are certain components that you'd be exposed to in medical versus the recreational. The plant product is the same itself.
Yeah, and I think a lot of the variations come around the regulations of them, the regulations of the sale, the tax, and then as you commented on you can't use recreational marijuana wherever you can't smoke. There is similar language, although it's not as strong in the medical marijuana law, and so that gets a little more complicated.
Okay, I'll go with this one next. Someone has a comment and a question. They said that managers and landlords can be gatekeepers, and the reason for not implementing or poor enforcement, or as they may smoke themselves. So is there a manager's lease or some way of putting, I guess, exerting some force against the manager themselves? Are they protected in the same way as renters, or is there flexibility to ensure that they are not the problem?
Again, it's the landlord that would set the policy, and that policy should be across the board for the tenants and the manager. So the one that sets the tone and the rules is the landlord. There are some managers that are a combination of managers and renters. So if a manager is also a renter, then they would be protected as a renter. But if it's just an employment situation, really it's the landlord that sets the rules.
And I think when we're dealing with ordinances that are governed by the city and maybe aren't set by the landlord or the manager, that's where you're paying extra attention to who you are authorizing to enforce that policy. comes into play, and there are, you know, different ways of enforcing these policies throughout that communities have taken throughout the state. Some have code enforcement that are tasked with going out and checking up on complaints, but in some places it is the landlord as the first line of defense against it, and in those cases, that's where you really want to make sure you do have an ordinance, back to Esther's point, because then you have layers that you can follow through to try and force that landlord or manager to enforce the law if they're not doing so.
And also with that, whether it's, especially when it's a citywide policy for ordinance, having a good educational component as part of that implementation and rollout. So setting the expectation for managers and other landlords of, you know, this is what's anticipated, these are the steps you can take. So, you know, sometimes it's, from my perspective, it sounds like people often aren't doing the best job around enforcement because they just don't, they're really stuck. They think it's really confusing, they don't know what to do. So if we can help with the education component around, here's what you do, that might facilitate some better, you know, communication and implementation compliance.
Yeah, I think that's a good point, and making sure that education component isn't just targeted towards the tenants about how this new policy is going in, but also educating the folks that are responsible for putting it into place on how to do that.
One of the questions here is, and I think you guys answer it in a way too, is how has medical marijuana been handled in other areas where smoke-free ordinance has been implemented?
Interestingly, California is the only state that has citywide multi-unit housing ordinances. There's about 46 cities and counties in California that now have 100% smoke-free multi-unit housing laws, and those are the same 46 in the whole country. So while there are other states like Colorado and Washington and Oregon and Alaska that have legalized recreational marijuana, they are dealing with their marijuana in a wide variety of ways, and they too are facing a variety of challenges and pushback around in making sure smoke-free spaces stay smoke-free, including the marijuana. But in terms of specifically housing laws, they haven't encountered there. But we know that landlords are looking at including marijuana in their own policies to ensure that there's protection there.
I have another one. It's mine. It's kind of a comment and then a question. I know a lot of jobs require, I've had a couple different jobs, like in a hospital or, you know, government jobs. I know military requires drug testing. And secondhand marijuana smoke, I mean, sometimes I'll go through a cloud of it and I'll be worried all day and night until, you know, the next monthly testing. And, you know, that might pop up, even just that secondhand exposure. So that's my comment, and then my question is then, Councilmember Koretz brought it up, so not to kind of put him on the spotlight, he's not here, but what is the difference between medical and, what is the difference between smoking it? Because in my understanding, when you burn something and smoke it, that's kind of always bad because you get, you know, combustible, you get tar, you get more particles. So why would it be necessary for someone with a medical issue to set a fire or something, combust it? Why wouldn't, and I know, you know, this is controversial, but why wouldn't vaping be the only alternative if you needed to get it into your lungs? But, you know, definitely edibles or pills. If we're going to say that it's a medicine, why does it need to be smoked? What is, I mean, he brought that up, so I kind of want to ask him, but if you guys know, if anybody here knows, I just want to empower us so that when people bring that up, we can say, well, no, actually there isn't this much, or maybe there is to smoking it, but that's only for this particular case. Thanks.
With that, I want to add this too, maybe that could be added with that question. Are there any evidence-based control studies that conclude patients who try multiple cannabis delivery systems such as spray, eatables, and oil, verified that show that are in fact patients who only get relief from smoking?
I can speak to your first question regarding the drug testing. I heard Dr. Suzanne Schick at UCSF speak last month on some of the awareness, some of the known information about the marijuana smoke. And one thing she did say is that in terms of drug testing, people probably are unlikely to register a positive test from secondhand marijuana exposure because because of the way your body processes it and the amount of THC you'd likely to be taking in and processing would be relatively low. She said certainly anyone who smokes it actively would turn up on a drug test, but her opinion based on what she's been looking at is that the secondhand exposure for drug tests probably would not be terribly great. In terms of, I mean, I'm no expert on the medical marijuana, all the medical reasons and types of smoking, so I can't specifically speak to that. We have heard that the smoking and vaping of it delivers the effects faster, so that's why people with medical needs may prefer it over some of the other components, but in terms of the effectiveness, in terms of addressing issues, I can't speak to that.
Okay. And I don't know that any of us up here are the medical experts on that issue. I know I'm not comfortable answering that question. You know, I think it does tie into the second question that was asked, which is this question about research that exists that shows the effectiveness of different types of cannabis. And I think that this comes back to the question of there not being a legal way to really run these tests up until this point, and I believe in the next several years we'll see a lot more information come out looking at some of this now that it's legalized here in California, and there'll be more of an ability for the researchers here in California to do some of that research, but unfortunately I don't know that any of us are able to answer that. And then I think we have time for one more question, and then I'll turn it back.
All right, so I have a lot, but I'm gonna read a comment here. It says, people who want to smoke marijuana for the medical reasons and use fair housing law to request a reasonable accommodation to use it in their apartment unit need to be informed that the California Department of Fair Housing and Employment Housing isn't accepting this kind of requests.
Yeah, so for reasonable accommodations, for under federal law, they are not allowed to, you cannot get a reasonable accommodation to be allowed to smoke medical marijuana under the federal law because it is still a Schedule I drug under federal law. The law for getting a reasonable accommodation under state law is a little bit unclear. There was a case a while back, not related to housing, but for an employee who asked for a reasonable accommodation for like the type of drug test you were just talking about, which the court said was not allowed. So they weren't allowing reasonable accommodations for an employment. You can kind of assume that they might apply the similar logic to housing, but it hasn't been settled yet. So that might be something that plays itself out in the next few years.
Okay, well, thank you to the panel. I hope that anybody that has any additional questions feels comfortable coming up to any of us and asking any of us questions or reaching out to us. And I'll turn it back over to Marlene now.